Delivering this week's must-watch workplace storylines, this is Bloomberg Law's Punching In, for those of you listening in Washington and across the globe.
Welcome, and thanks for punching in with us today. I'm Hassan Kanu. For our first story, there's still a holdup at the Department of Labor over rules governing who's eligible for overtime pay. My Bloomberg Law colleague, Madi Alder, will join us now. So, Madi, tell us first a bit of background. What is the salary threshold? And then could you please tell us what the overtime rule is?
So the salary threshold is the amount that you can make to be eligible for overtime pay, which is time and a half. And if it's at a higher cap, if that threshold is higher, more people are eligible. And then at a lower level, that means that less people are eligible. So pretty straightforward. And the Obama administration tried to set this cap a little bit higher, moving it to $47,500, but that was challenged and is now held up in federal court. And so right now, it's back at the levels from the Bush administration, which is a little less than $30,000.
And what is going on with the rule now? What's the future of the overtime rule?
Well, that's a great question. No one's really sure. The DOL hasn't introduced a new rule, but both sides, business groups and worker groups, are pushing for a new rule. The business community almost definitely will sue if an increase is tied to inflation. And worker groups probably wouldn't be happy and also might sue if the threshold is set lower or kept somewhere around those Bush numbers.
And what is, do we know the reason for that? What's the holdup?
We don't know the reason for sure, but one issue could be that Trump's nominee to be the head of the DOL's Wage and Hour Division, Cheryl Stanton, hasn't been confirmed by Congress yet. And the Wage and Hour Division is a department that handles this rule. And another issue is that DOL Chief Acosta doesn't really like to upset stakeholders, so he's probably also being cautious. So I guess we'll see what happens in these coming months when and if Stanton is actually confirmed.
Thanks for joining us, Madi.
Thanks, Hassan.
In our next story, the nominations game between Congress and the White House over a slew of labor nominees continues. There are several nominees for positions at the Department of Labor, about 3 of them, and at least 1 for the Equal Employment Opportunity Commission. Those folks might have a lot more waiting to do if they're not confirmed by the end of this year. President Trump will have to renominate them, and they'll have to go through the Senate again if that doesn't happen. Congress, of course, I think we learned this from the Nunez tapes from last week, is prioritizing the Kavanaugh vote, and then lawmakers will have to hit the road to campaign for the midterm elections. So that might not happen by the end of the year. There's also a chance that Democrats, there might be new Democrats and new Republicans, of course, as well, in Congress and on the Hill in January. Those folks might demand additional hearings for some of the nominees that they haven't heard from, or just if they oppose them, or even just to try and slow things down. So it's likely that most of those nominees will be held over past a year. Stranger things have happened sometimes, but we will keep you updated on that. In our next story, gig economy companies are seeking some guidance from the Department of Labor. Those companies know whether some guidelines that the DOL recently put out applies to other in-demand sorts of jobs, like Uber drivers, different delivery services, whether that's food or all the other odds and ends one can have delivered nowadays. The Department of Labor put out a guidance document last month for what's known as healthcare registries. Those are essentially businesses that maintain lists of caregivers, home health aides, personal care attendants, folks like that, and they match them up with different people who want to hire someone for that at-home service. So that document basically tells those businesses when they're considered an employer, quote unquote, of the people on those lists under federal wage and hour laws. That's a legal definition that comes with certain obligations for the business to pay those workers time and a half overtime pay. That came up earlier, of course, and at least a minimum wage as well. That guidance lays out very specifically for these healthcare registries when and how their business models essentially cross the line from independent contracting to actual employees. And that's based on how much control they have over the workers day to day. So sources are telling us now that other industries in the gig economy, other sectors, might soon request an opinion letter specific to their own industries from the Department of Labor's Wage and Hour Division. That would be specific to their own business models and tell them exactly how to maintain their independent contractors, or when they've crossed the line and are now considered a formal employer that owes overtime pay and minimum wages and such. All right, that is it for today. Be sure to punch in with us again next week for a rundown of what's happening in the labor and employment space. Have a good one.